Right. Has that motion been ruled on?
I have not officially ruled on it, but I'm asking to finalize the instructions, and if you want that instruction in there, then we've got to figure it out right now. So the question is, are you consenting to the instructions as they are presented here, or are you saying that you still need additional instructions, specifically the Willits instruction you're requesting?
Yes.
You are requesting that still?
Yes.
Okay, does the state have a position on that?
Yes, Judge. He is asking for it based on the fact that the victim did not come testify, and so therefore that is somehow the fault of the state. Your Honor, a Willits instruction is specifically for the state failing to preserve, lose, or destroy evidence. I can certainly avow to this court that the state did everything within its power to attempt to bring Ms. Horton here. The reason I did not ask for a warrant is because Ms. Horton is out of state. By the time we discovered where she was, it was too late to serve an out-of-state subpoena on her. Further, as maybe Mr. Pennington isn't aware, but this court is aware, the length of time that a person can be held on a material witness warrant is very limited. I do not believe that the state that she is in would have extradited her to Arizona within the amount of time that we were currently in trial. So a warrant would not have changed the circumstances in this case under any circumstances. And a victim deciding at the last minute not to come testify is at no fault of the state, let alone willful or not willful. I can certainly avow to this court that I spent that it was not, that we did make significant efforts to bring Ms. Horton here to testify, and it was not our intention under any circumstance that she wouldn't testify. We were intending to proceed with her testimony all the way up until I discovered at 5 o'clock in the morning, on the morning she was supposed to testify, that she decided she wasn't getting on an airplane. And so I don't believe that he's proven any basis for that Willits instruction, and that's my argument, Judge.
Mr. Pennington?
The state has proved no evidence that she is in fact out of state. So that is, speculation. And they had more than, I've been in, jail for 5.5 years. They had more than enough time to get Aviana here. And then they didn't exercise all remedies or avenues to get her here, like a material witness order. So that right there just proves, they didn't have all their ducks in a row coming to trial. So they were, bluffing. So, and when I called their bluff, all of a sudden now she's not coming to testify. So it is the state's fault, Aviana not being here to testify. If she was here to testify, it would strengthen the state's case. But the only reason they didn't force her to come testify because she was going to say exactly what she said in that email. that I never touched her, and also in the Buckeye police reports when she told Adrian Walker that she only had sex with Camille, not me. So either they did it on purpose or, you know, they didn't think I was going to go to trial as pro per. So it's the state's fault that that evidence the jury could not hear, exculpatory evidence. Right now I'm on charges pertaining to Aviana, specifically count 6 and count 7 really too. And she cannot corroborate Aaliyah Barkanir's testimony. I mean, she clearly said I didn't have sex with her. Aaliyah Barkanir testified to that. And Aviana is also saying that I didn't have sex with her. So why am I still charged with at least count 6? Maybe 7 we can argue, but at least count 6 should have been dismissed yesterday. Now, I would like to argue oral motion Rule 20 for both charges, again, because the state can't prove beyond a reasonable doubt that what the charges that it actually happened. There's nobody to corroborate Aaliyah Barkanir's story. The only person that could have connected those dots was Aviana Horton. The state failed to preserve that evidence. Lost, destroyed, failure to preserve. That's all on the state. And the jury had the right to hear that information, exculpatory information. Since she is not here, that's why I feel I filed the Willis instruction to instruct the jury on that, Judge.
All right. Anything else, sir?
No, Judge.
All right. I am denying the motion to give the Willis instruction. I don't believe that this is a situation where the state has lost, destroyed, or failed to preserve evidence. I know you disagree with that. I understand why you disagree with it. But I don't believe this meets the requirements for issuing that particular instruction. So I'm not going to order it. I'm sorry, I'm not going to instruct the jury with the Raji 42 instruction that you're seeking.
Rachel Mitchell continues to stand by her earlier decision to dismiss charges against a Valley man who's now accused of sex assault on multiple women, even a teenager.
A grand jury indicted James Estep on 30 felony charges last week involving 6 alleged victims dating back to 2018. ABC 15 investigator Ann Ryman questioned the county attorney today.
County Attorney Rachel Mitchell at a news conference Wednesday. She explained why she decided to drop the case against Estep earlier this summer and then file charges again, plus more, after a new alleged victim, a 15-year-old girl, came forward. We asked Mitchell what message this sends to the community.
I'm going to look and make sure that the evidence is there before I go forward, because that's the ethical and responsible thing to do. Sometimes that leads to heartbreaking situations like this.
Estep is accused of raping women in the Valley for 5 years before his latest arrest and now grand jury indictment. He's being held on a $500,000 bond. I'm investigator Ann Ryman, ABC 15, Arizona.
And